Come on in. Come on in. Say hello. Say hello. Hi, everybody. Good evening. Ẹni àtijọ́ ṣe dáadáa ni. Ṣé máa fi ọ lẹ́wọ̀n? Hello, Illinois Sanctuary. Hello, hello, hello. Hi, everybody. Come on in. Say hello. Come on in. Say hello. Yo, birthday is loaded. So I was like, am I doing a party? No. I'm not doing any. Yo, I had a party on my 40th birthday. I'm doing party. It's just about. So actually, TJ has offered. TJ's offered to celebrate his birthday with me because TJ's birthday is on Sunday. My baby's gonna be 13. Happy birthday, TJ. He's gonna be 13. Finally, we're getting to be a teenager. It's about time. TJ's birthday is on Sunday. My birthday is on Monday. So literally, I spent my 32nd birthday in the hospital. Hello, ni agba. Omonla. Well, not be Omonla. This TJ is so kind. I hear you. Ask him who's paying for it. But yeah, that was a sweet gesture. He was saying like, oh, hi, how about we just celebrate our birthdays together on Sunday? But funny thing is, that's how it's always been. Like people just call me on his birthday, like, hey, happy birthday, TJ. I'm like, oh, by the way, she won't know she birthday, Lola. Won't know happy birthday. Oh, that's how it is. Yeah, that's how it is. Well, hi everyone, come on in. Hello, Mr. Richard. How are you? Let's like Joy. How have you been? Yeah, mama and son. My sidekick and I, we have birthdays back to back. Hi, TikTok family. Hello, Facebook, YouTube, Instagram people. So thoughtful. All the teachers and aunties are here. Yeah. Hello, Mayo 331. He wouldn't glasses me. Wow. Is it 331? Yeah. Oh, good evening. How are you? Hi, everyone. Come on in. Say hello when you come in. 𝒊𝒎𝒒𝒊𝒈𝒓𝒂𝒏𝒕, who are you? Shidada lady. Oh, someone sent me. Oh my God. Well, sent my assistant Lydia, and she forwarded it to me. Well, they said, tell the attorney to stop making videos in Yoruba language, because not all clients speak Yoruba language. No comment. No comment. But it's the nature of that's what it is. But hi everyone. 𝒊𝒎𝒒𝒊𝒈𝒓𝒂𝒏𝒕. Right? I think so. I'm telling you, it's like all kind of stuff happens. Just like telling somebody who is a bilingual, like Spanish speaking attorney, like tell them to stop making videos in Spanish. It's funny, the person you're talking to. Stop what? Wait, listen. You just. But we're early today. Those two adopted sisters of mine, Miss Abena and Miss Illinois Sanctuary. Not that you should say something. Like we are actually right. I think we're on time or close to being on time. Anyway, it's early today. But hi everyone, this is attorney Abisola Adebola Olale. I'm an immigration attorney based in Alabama, representing immigration clients in all 50 states. Doesn't matter what state you live in, got an immigration case. I'm telling you, got an immigration case. We can and do represent immigration clients no matter what state you live in the United States. Immigration practice is federal practice, is federal law. That means that an immigration attorney who's licensed in any state can represent you in your immigration case as long as they're willing to do that. And that's what we do. But anyway, yes, and we represent clients in all 50 states. Our contact number is 334-341-4475. Website is olalayelawfirm.com. Thank you, everybody, for always tuning in. I appreciate it. I do not take it for granted. 10 minutes late. 10 minutes late. I'll surprise you. Just wait 1 minute. Once again, our contact information is 334-341-4475. Same number on WhatsApp. Text us. Call our office. Once again, if you send a message on WhatsApp, it will give you an automatic response. We don't accept calls on WhatsApp. You have to call the office directly. We use WhatsApp for our text messages, so sending consultation information. So please, if you have to call our office, call directly, not on WhatsApp. So TikTok, Facebook, Instagram, YouTube. Subscribe to YouTube channel at 𝒊𝒎𝒎𝒊𝒈𝒓𝒂𝒏𝒕 Immigration. Hello, Miss Gima. I saw your email. I just haven't had the time. When I say I saw your email, because I saw your name, I just haven't had the time to get to it. So I'll get to it once we're done. So I will send a response. TikTok, Instagram, YouTube. I have this really driving me nuts. Facebook at 𝒊𝒎𝒎𝒊𝒈𝒓𝒂𝒏𝒕 Immigration. Same thing on YouTube. Subscribe. Tons and tons of information, tons of content that can be very, very helpful. So please share this video with people, your friends, family. That will be very much appreciated as well. Let's talk immigration, people. So real quick, I wanted to talk about yeah, I love that. Oh, so yes, birthday's coming up on Monday. Ms. Venus said, for all birthday, contact at @leakfinger_. And for those, no kidding, for those who have actually contacted her and placed orders, I am very, very grateful. No, for real. Like, I was kidding, but not really, because her food is good. If y'all haven't tried Leak Finger food, someone's like, okay, this is like she haven't tried. No. This is genuinely because she's got her cooking is me. I'm very, very particular about my food, and if it doesn't taste well, I ain't gonna come back to you. So if I've ever bought something, I'm not coming back just because I don't like it. I've lost count how many orders I've placed with her, for real. That's just because the Odogo, she's the Odogo meat pie. See, there are other people who have ordered from her. I ain't kidding. And if you're like me, I love my sausage roll. And she made me Niger suya, like real, like I felt like I was like 𝒊𝒎𝒎𝒊𝒈𝒓𝒂𝒏𝒕 Abuja. Was it like it was a Garki area where all those guys, those suya guys would line up, and oh my goodness, don't even get me started. And she had mixed it, and I was like, I'll be damned. Like I said, my kids were like, what is the big deal about this meat, and what does it smell like? Oh, I'm from America. I can't explain to that. They can't get it. It was just that was life. So area 1, yes. That was because I went to law school in Bari campus, so I was in Abuja for a year and a half. And when I was married, I lived with my ex-husband's family for a while, so I lived in Abuja. So, but anyway, and for all those who have reached out, area 1 Abuja, yes, my oldest baby moving to college. Pray for me, people. Had a rough night last night. I'm not gonna lie. It was really, really a lot of turning and tossing and all that. But no, you gotta understand. This is a kid that doesn't take photographs, but because he wanted to make sure his mama was fine, and he's probably watching me. He took a selfie, like literally. Yes, he took a selfie and said, like, "See, I'm okay." And I'm like, but I've already FaceTimed him like 3 times today. Y'all don't judge. For those mamas who have first kids, especially first sons, and they're just leaving you for the first time, y'all understand. Well, anyway, let's talk immigration, people. Once again, 334-341-4475. That is our contact information, contact number, 𝒊𝒎𝒎𝒊𝒈𝒓𝒂𝒏𝒕. Thank you so much, everyone, for coming in and joining, and put your questions in the comment section. We'll get to them as we always do later on. Okay. We'll get to them as worries later on. So, I-751. I've been getting quite a number of those petitions where the petitioners are looking to file or to convert from a joint petition to a self petition, and they're not sure. Thank you. They're not sure what route, what they're supposed to do, what is the normal procedure. Am I filing a new form? What exactly? Cecilia, help me out. What's going on? What am I supposed to do? So let's talk about that this evening. So that's what I want to talk about. I-751 conversion. Do I need a new form? Do you need a new form when you're going from a joint petition to a self petition? And when can you file it? When can you convert? And what documents do you have to send in for your request? So if you are in that position now, and I can tell you this week as of Thursday. So yesterday I blocked out all but 2 hours because it was about my kid yesterday. But this week alone, when I tell you that I've had no less than almost, I think right now, counting today was about 9. For 751 joint petition related cases wanting to convert, but people are not really clear. Am I filing a new petition? Am I, just sending a request to USCIS? What exactly is the route to go? So that's what we're going to talk about. Do you need a new form? When should you convert your self-petition in the I-751? What exactly would you expect? Can someone let me know on, because I was having, can y'all hear me? Am I breaking up on Instagram or on TikTok? Can somebody let me know? And same thing on YouTube and Facebook. Watching from DC. Okay, I'm good. Okay, good. All right, because Xfinity, I'm not really sure. I always find with USCIS. Xfinity wants to, please kindly share this live to your family and friends. You never know who might need this information. Hello. All right, good. Hear me loud and clear. Awesome. All right. So whenever you file an I-751, or when should you file a 751? Now, let me address this. Y'all will be surprised how many people actually instead of filing an I-751 petition to remove conditions in residency, file an I-90, which is to renew or to replace your green card. So we're in August. I've had about 5 of those cases where either the client has, all my current clients heard me talk about that, or they were wondering why the case is taking too long. We have a consultation and I go, well, you filed the wrong form. So I-751 is what you need to go from a conditional green card to a 10-year green card. That's what you need. I-90 is for you to replace your 10-year green card or replace your 2-year green card if it's not expired yet, or to replace your lost green card or expired green card. They're completely different things. One, you already have, you're just replacing the card itself. The other one extends, you remove the condition from you going from a 2-year to a 10-year. So it's important to know the difference. I-751, generally, you have to file with your spouse. That's the general requirement. You have to file jointly with your spouse. However, there are situations where you may not be able to file with a spouse. Those situations are what we would call self-petition waiver-based I-751s. They are either you're filing because you got divorced from your spouse that you got your green card through, but you married the person in good faith. So you joint petition, a self petition, all of that, you're still required to prove good faith marriage. The only waiver ground and an I-751 that does not require the proven good faith marriage is if you're basing it on extreme hardship. It is the hardest waiver ground to prove. It's the only one that does not require you to show that your marriage was in good faith. But generally, most people file jointly, or if you're not filing jointly, that's when you consider a self-petition, meaning I married the person in good faith. It was a bona fide marriage, but we got divorced. The marriage did not work. I married the person in good faith. However, during the course of the marriage, I have now been subjected to abuse. I married the person in good faith, but something happened to them. Mistakenly they ate rat poison and they're dead. Just kidding. But if that happens, where the spouse passes away, good faith, but the marriage was terminated by death of the petitioner, then that's a waiver grant to file. Extreme hardship is basically, it doesn't matter what you married the person in good faith, but if you're not allowed to get your 10-year green card, you're going to be subjected to extreme hardship. And there are a lot of factors that can be that it's very broad and it's very discretionary. So for the most part, most people don't use that. if you have a pending I-751 that you and your spouse have filed, now you guys are going through a divorce, and you know that most likely that divorce is going to be final before your I-751, because it's taking, now keep in mind, people, when you file an I-751, USCIS is sending you a 4-year extension notice. You're sending a 4-year extension notice because it's taking forever for them to adjudicate I-751 petitions. It used to be 18 months, then it became 24 months, and now it's a 4-year extension notice. So the 4 years starts to count from the expiration date on your 2-year green card. So if your 2-year green card has expiration date of August 17, 2023, the 4-year green card, and you've already filed a 751 before today, it doesn't, the notice does not kick in until August 17, 2023, and it extends it for another 4 years, 48 months. So you get that. However, you file this jointly with your spouse, you get your extension, something has happened, you know that marriage is not going to last, and most likely that divorce that you just started is going to become final before you get your 10-year green card. Hear me loud and clear when I tell you this. If you are in the process of getting divorced and you have a 751 that is pending, please, 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 and please do not, or if you're in the process of divorce and there's a possibility that divorce is going to come through before you either get scheduled for an interview or before your I-751 is approved, do not try to hide that and now allow USCIS, especially now because they're waiving a lot of interviews. Do not, conceal that information and get your 10-year green card, because here's what's going to happen. If your 10-year green card is issued based on a joint petition, and that joint petition, that green card is issued the way you have an interview waived, and that green card comes after you have been divorced from your spouse, then that means that the joint petition was not valid. It was no longer a joint petition basis. It was going to be a self petition, and that could come back to become a problem for you when you apply for citizenship, because USCIS can go back and say you were not eligible to get your 10-year green card, and that could jeopardize your status, putting you in harm, so you can potentially have your status terminated just because you failed to inform them that you had gotten divorced before they approved their case. The best thing to do is communicate with USCIS, let them know divorce has happened. I'm requesting that my joint petition be converted to a divorce waiver. And so if a divorce is in process, if you fight jointly, but somehow things are not working out, you've become a victim of abuse in the marriage. Another thing is, I get this question a lot. Sister Elijah, can divorce? Do I need a divorce? I'm being a victim of abuse, or can I just file based on abuse and still continue my marriage? There's no requirement for you to be divorced in order for you to use an abuse self-petition basis to file a 751. There is no requirement for you to be divorced in order to use the abuse ground, self-petition ground, in a 751 petition. There's no requirement. So you can actually be in a marriage, your marriage can go on, have kids, whatever case may be, but still have that self-petition based on abuse. So divorce ground, abuse ground, extreme hardship, or your spouse unfortunately passes away. Do you not need to file a new form in order to convert from a joint petition to a self-petition? Short answer, no. All you need to do is inform USCIS, basically the office that has the way your case is pending, not necessarily where you sent it to, the office where your case is pending. How would you know that? If you're still waiting for an interview, your receipt notice in the bottom left corner will have the office, either the actual field office or the service center where your case is pending. That's where you send your request to. You send a request to USCIS saying, hey, we filed jointly, or you have situations where because of abuse, your spouse now maliciously wants to end your case. That's another reason for you to convert to an abuse-based case. Send it to the USCIS field office or service center that's over your case. Attach a copy of your 751 receipt notice, extension notice. That's the same thing as your receipt notice. And then a written statement telling them, explaining why you are converting from a joint petition to an abuse ground, from a joint petition to a divorce ground, from a joint petition to an extreme hardship ground. Explain that in an affidavit. There's no, formal way, but you've got to have that request in writing. Attach a copy of the 751 receipt notice, and that's all you need. You do not need to send in a new I-751 form in order for you to convert from a joint petition to a self-petition. Sometimes USCIS will still schedule your interview, and you may not get. So people always ask, will they send me an acknowledgement when I make that request? Short answer, generally not. If you've got a situation where a joint petitioner, meaning your spouse, you filed jointly, on their own, send a request to USCIS to withdraw their own withdraw being a joint petitioner. Most of the time, USCIS will inform you, the 2-year green card holder, that your spouse has decided to withdraw their joint petition filing with you. Do you want to convert to a self-petition? That you get that chance. So that's one, and that's probably one of the things USCIS will send you. If that doesn't happen in your case, and you're the one requesting for a conversion from a joint petition to self-petition, most of the time you will not get any acknowledgement. You just have to wait. Sometimes USCIS will waive that interview and you get your green card. Other times they may not waive an interview, schedule you for an interview, and if that happens, your interview notice may still say attend with your wife or attend with your husband, whatever the case may be. The best practice is take a complete copy of the request you made to convert from a joint file case to a self-file case. Take a complete copy of that request with you to your interview. Make sure you have that. The best practice, another best practice is anytime you send anything to USCIS, that is without fail. That is just, it's non-negotiable in my firm. If a mail is going to USCIS, believe it has a tracking number and somebody who signed for it. Because they ain't gonna, and I cannot tell you how many times we've been able to get service request motion to reopen done based on being able to show that somebody in your office by the name of signed for this package, y'all ain't gonna tell you didn't get it. Okay, so always make sure you have at the very least trackable mail that you send it through trackable mail, UPS, FedEx, USPS, something that you can have to show that you indeed sent something to USCIS. Because like I told you guys 2 days ago, we sent something 2 weeks before an interview. They didn't even open it until the day off. There was nothing they could do. The supervisor were almost just short of apologizing because they left it in the mail room. But guess what? We already had proof that it was confirmed. It was signed for. Somebody just tossed it up without any care in the world. Unfortunately, that's some of the things we have to deal with. So once you do that, if you're scheduled for an interview, take your file with you, have everything that you had sent in, so that, because sometimes if your case is at a service center and that's where you send it to, it may not make it to the field office. You will think that everything you send in should be your complete file, should be scanned in. That would be in an ideal, in a perfect world. It doesn't work that way with USCIS. So even if you've sent it in, be sure to take everything in with you and asking them, letting them know, hey, we sent this. This is a proof that it was sent on this date. But just in case you don't have that in the file, this is a hard copy again of what was sent in requesting to convert from a joint file I-751 to now a self-petition I-751. Here is my reason: divorce, abuse, hardship. My spouse unfortunately passed away. You do not need a new I-751 form. All you need is your extension notice, request to USCIS, additional proof of why you're converting to a self-petition. For instance, if it's abuse case, if you've got psychological evaluation report, you got photos of injuries done to you, your declaration telling about what happened with emotional, non-physical abuse. That is all you need to send that in. Reiterate that it's not what I do is I have a bold cover page, red font, like any people, red, right? That kind of thing. This is not a new filing, because if you sometimes it does happen to be before, so that's why I started doing that. They thought it was a new filing. They sent it back like you didn't put filing fee. I'm like, yo, I wasn't supposed to put filing fee because I just told you I'm changing from. So I said, you know what? I ain't gonna argue. Resent it. Put the bold cover letter, cover page. Please note, It's not a new filing. It is a request to convert from a joint petition to a self-petition. Here is a copy of the receipt that we included the first time showing that fee was paid. So when you do that, sometimes this is where you may get an acknowledgement. If you had a 751 filed yourself, and in every single case that I have that except one, I think only one I'm waiting on. Sometimes, or most of the time, I would say, USCIS will send, and now you have a new counsel, once the name of the person is on your case, USCIS will send me, which they've done several times, a new extension notice. Once we've made a request to convert from a joint petition to a self-petition, they'll send me a new extension notice, still the same receipt number as the first time, and it would say, rather than, a new fee, whatever, it would say fee previously paid or fee waived or something. It's just basically saying we're acknowledging that you already filed this, and this is our acknowledgement that yes, we've received your request to convert. That's one of very, very specific situations where you can actually get an acknowledgement that they received your request, because I usually would get a new extension notice and just let the client know, hey, here, this is my confirmation that they have added my name to your file, and they've also acknowledged that we've made that request to convert to a self-petition I-751. And that's all you need to do, people. That's it. Very simple. A lot of things should not be complicated, but that's how you need to go. That's what you need to do when it comes to converting from joint filing 751 to a self-petition, and that's all she wrote. Okay. Let us go to questions. Okay, I want people in song. Okay, let's see. Let me start. All right, let's start with TikTok today, because I think I already started with Facebook. Oh, well, let's start with TikTok today. Put your questions in the comment section, and we will try to get up to all questions, as many questions as I possibly can do tonight. Let's see. I am a U.S. citizen, but my kids are permanent residents. How do I apply for them to become U.S. citizens? So, general information. Hey, Nikki. General information, nothing specific to anybody's case. Specific information to your case is done over a paid consultation. 30 minutes, 130, 245 minutes, 231 hour. Now, I haven't decided yet, but I may most likely do for birthday week. In honor of birthday week, I probably would do a promotion for consultation just next week. I'll see. I think we most in my luck office me lot guys. It's letting go. There's no, I haven't. No, if there is, Lydia will probably post it. We'll post it, but most likely we will. Just being grateful and thanking God for 45 years, 4 decades, 4.5 decades. Lord have mercy. Y'all remember when our parents turned 40, like 40, 45, 50, and we're like, I'm going to move to Dagmar. And now we're, at least those of us who were at that age. And like, I'll be damned. Where did the time go? Exactly. Don't start calling the office tonight, because I ain't saying nothing yet. But anyway, so if you are a U.S. citizen, Frizzell, if your children and they're permanent residents, if they're under the age of 18, then at the time you became a citizen, they're in your physical custody. At the time you became a citizen, your children would have automatically acquired citizenship from you. If they are or they were over the age of 18 when you became a citizen, then they've got to file their own citizenship. If you're not sure, when in doubt, the best practice is consult with an immigration attorney so you know exactly what you need to do. I have work permit. Can I go to Puerto Rico? Puerto Rico is a work permit is a form of identification. Work permit is not a travel document. How do I transfer I-130 receipt date to I-360? My U.S. citizen filed I-130 3 years ago. My file was 2 years. So let's address that real quick. There is the policy that allows you. Where is my? Hold on. I need to. TJ. T. Okay, never mind. I got it. Never mind. I was going to tell you to come do something. I got it. Okay, there we go. There is the policy, no policy, the section of the Immigration and Nationality Act that allows you to actually transfer the priority date of an I-130 to your VAWA case. It doesn't matter whether that I-130 has been denied, revoked, withdrawn, whatever case may be approved. As long as you were the beneficiary of the I-130, the law allows you to do that. What I do for my clients, and I cannot tell you that it's 100% proof. No, because I've got about 2 cases that every single month or every other month, I'm always emailing Vermont Service Center like, yo, people, y'all, you got to make a decision on this because it's been, by calculation using that priority date, it's outside number processing time, right? So what they're required to do, and that's what the policy says, even on the USCIS.gov website, that should result in you having an earlier priority date, meaning that your case should be now decided based on the date that your I-130 was filed. And if that's the case, if you've had 3 years, it was pending, by calculation, USCIS is taking anywhere from 33 to 36 months to process an I-360 petition. So if that's the case, if you're reaching 3 years and your I-130 was filed over 3 years ago, reach out to them, reach out to your attorney, email them and say, hey, and that's what I do for my clients. I've had cases where, and the way you would know if your priority date has been applied to your VAWA case is when you get the VAWA approval notice. There will be the receipt date and the approval date, right? And the notice date, receipt date, notice date. Then there'll also be a section that says priority date. All the cases that I've had approved that had previous I-130s, all their priority dates actually match the priority date of the I-130. And those cases, but maybe 2 or 3 that I said were still pending, were actually less than 36 months because that's what the law allows them to do. So, and I just wanted to take time to explain that. To your question, ask your attorney to write a letter. You can do that. Send an email, which is what I do, and I've done on behalf of clients. And it's not automatic, but it puts them on alert that you're aware of what the law is, and at least puts them on their toes that you've got to keep checking on them, but you have to make the request in writing first. Is a elope wedding acceptable from USCIS? I mean, nothing says you can't elope, but whether or not it's going to be a red flag, that is. Fazell says you don't answer questions. I'm going to say this again, and I know I've said it several times. Fazell, I'm sure I just answered your question. If you're joining us for the first time, we have a system. I don't answer questions until we are done talking about whatever topic it is we have to discuss. If we do question sessions, which we do every other time, then we're doing questions going around on 4 different platforms for Zelle. So, y'all, I'm telling you, we immigrants and with the most impatient people. Put up your hand if you're work in progress when it comes to patience. Yes, that's me. I think I started having patience when I became a mom. But that's what we do, Fazell. So, but I've already answered your question. And it's general information. Y'all have to be very, very, I won't say what I was going to say, but anyway. Can your spouse use the green card to file for you? Can your spouse use the green card to file for you if you're still an asylee? Carol, can you rephrase your question? I'm not really sure I understand what you're asking. Okay. My hearing was canceled and said to file pleading what to expect. If you have Benicia, if you have an attorney, they will know what to do. So basically, the judge, the court is allowing to file written pleadings in lieu of having a master calendar hearing. How can one contact you? Contact information is 334-341-4475. Let's see. What if after 4 years extension, there is no adjudication yet? It's still possible, but by the time you're at 4 years, you're already due for citizenship, either whether it's 3 years or 5 years. If you are still waiting 4 years on your 4 years extension, that's basically you've been a resident for going on 6 years. Maximum of citizenship is 5 years. So at some point you qualify for citizenship. So go ahead and file for your citizenship. Sometimes that actually speeds up the process. Half of my cases that helps. Some cases you're still waiting, but go ahead and file for citizenship because at that point you qualify. That usually helps to speed up your process. Is it the same form that is used for I-751 waiver? Yes, that's exactly what we talked about this night. That's in a nutshell. You don't have to file it. There's no other waiver form. It's the same form. If you look at the 751, I believe don't quote me on this, but I think it's on page 3, either page 2 or 3, one of those two. It asks you what is the condition by which you are filing to remove conditions of your residency. There's joint petition with my spouse, and then there's, I think options 1, D, E, F, I think. Yeah, is where the waivers fall. So it's still the same form. You just have to check. Now, if you did a joint filing, you don't have to send in another form. Just send in a written request that you're converting from the previously joint filed petition to a self petition now. That's all basically all you have to do. Cecilia, you're really trying to govern your strength. Thank you. I appreciate that very, very much. I filed for VAL and my kids filed VAL as well. Will our cases be reviewed together by the same officer? There's no telling. But if you file, when you say your kids filed for VAL, like did your kids file separate I-360 petitions? So, and I'm glad you brought that up. Y'all, this is why I do this, so that we can be knowledgeable. There's nothing more empowering than having knowledge, having a base idea of what it is that you have to do, what your case entails. I literally spent an hour consultation with a lady today whose kids' cases for VAR were denied. 4 kids, their VAR petitions were denied, and their companion I-485 applications were denied. Why, you would ask? She filed for VAL by herself. She filed hers. Her case is still pending. That's the funny thing. The children's cases, four kids, they each had to file an I-360 and then filed I-485, right? At some point, USCI sent them requests for evidence for all 4 of the children, asking to show proof that they were abused. They sent in the declaration that the lady mom who consulted with me today sent in, the declaration she used in response to the I-360 RFEs that USCI sent on each of those children, and all their cases were denied. Their cases were denied because the children were not abused. The children were not victims of abuse. Mom was the victim of abuse. All the 4 children are under 21, unmarried, they're really, really young children. But Mom did not use an attorney. Mom had somebody help her prepare the applications. Mom has spent, it would have been a lot cheaper, I'm thinking, or even a payment plan, something, to have used an attorney and get it right. Now she's out all the filing fees she spent for the children's cases because she was advised wrongly. So that's why I want to be clear. When you say your children's case is filed for VA, if your child was not a victim of abuse and you file a separate I-360 for that child, USCIS most likely would deny your case because there is no requirement for children who were not victims of the abuse to file their own separate I-360. In the unlike a regular marriage case where if your spouse is a citizen and then you've got minor children, they have to file separate I-130s for all of you because you're all immediate relatives. It's different in a VA case. In a VA case, that's one of the exceptions where citizens can have derivative beneficiaries, because if you are the spouse who was abused and you have minor children, your minor children do not have to file separate I-360s. All those minor children are just going to be listed on your VA petition. And as long as their names are on your I-360, then based on that singular I-360, everybody can file concurrent I-45 applications. Because if you file an I-360 for a child who was never abused, you're going to be wasting time. USCIS will deny that case because there is no abuse unless the child was a victim of abuse. So I hope that explanation kind of answers your question. But it's not, so it would depend on what did you file. Did you file separate I-360s for yourselves, or is it based on all of your applications are based on one single? So what do you mean by your children also filed for VA? Okay. Or adjustment of status interviews for VA applicants on the 20th typically waived, and anyone can be scheduled for an interview. Thank you for sharing, Miss Ruby. Can you file I-751 independently and not jointly due to divorce? That's what we just talked about. Short answer, generally yes. What do I do if my spouse abandoned the marriage before we were able to file? Been married for 2 years, consult with a lawyer and see what your options may be. Can I write to USCIS asking them to transfer priority dates, stating the immigration law? If you filed your case yourself, there's no reason why you can't do that as long as you're able to verify your identity to them. Okay. Sister Lawyer, are you Yoruba? Not my Yoruba skills, language skills, it's very questionable. So I can understand why some people are like, Yoruba auntie. So yeah. But yes, technically yes. Technically, because I have Yoruba. I'm partly Delta State. I've said that before. You already know. So let me go on multi-tribal. If my wife is fighting custody for her child, wouldn't that be a problem for her petition for me? That's a very broad question without knowing what the background of that situation is. I haven't received a receipt notice from Vermont in over 6 months. I wrote them in, and I wrote them and nothing. I'm guessing that's what the abbreviation is. What should I do? Consult with a lawyer. Let's see. Do you handle EB2 national interest waiver? Yes, I do. I have a green card. Can I come back in the U.S. after a year and a half outside of the country? If you're going to be outside the U.S. for more than a year, then you have to apply for a re-entry permit before you leave. Okay. AMB James, I have a question. If you don't mind asking, I think I have answered your question. What's your question? AMB James. Let's see. What is your question? After VAR approved, went to I-45, got approved, but status still says interview scheduled. Nervous, don't be nervous. Is USCIS. Your status may still say that even 2 years after you get the green card. Yeah. Okay, let's see. I have a lawyer, but she says that 130 cannot be transferred to. Okay, let's do this real quick, people. Let me do this and see if I can do it real quick. You may not be able to see it because you're on TikTok, but you can go on Facebook or YouTube later on. Sometimes it's just a lot easier to show that way. Let's see if can I or if no, that's not the one I'm looking for. Okay, yeah, exactly what I'm looking for. TikTok me. I don't know if you're on YouTube or Facebook, but I'm going to put these on. Let me see if I can. Give me 1 second, people, before I share my screen. Just wanted to show you guys because it's helpful if you're able to see exactly what I'm talking about. And let's see, convert. I'm looking at mine. Okay, here we go. Here's what I'm looking for. This is INA. INA. Let's see if I. Okay. So when we talk about this is to Anisru Equanisru Mumbo 2H2. This is 2H2. All right, this is ACD 2B. Okay, that's D. If you're going to E, just bear with me, people. E. Okay, here we go. 𝒊𝒎𝒎𝒊𝒈𝒓𝒂𝒏𝒕 A B C D E F G H. Okay. Okay, here we go. Let's see. Currently, okay. So I'm gonna put it. I'm gonna put this link. I think I will. Let me get. I'm just trying to get if Lydia can do this for us real quick. I'll put this link on our page, and okay. I'm gonna put this TikTok me. You want to go to? See, y'all can tell I'm a nerd. Don't be fooled with all the makeup. Like this is me. You can see me. Like I get lost in research, and I I get lost in research. I love it. I love it. This is my life. All right, so I'm going to share my screen. Okay, let's see. Share screen. And so y'all, because I know y'all sometimes sign in 2 different places. So if you want to see what I'm sharing, you're going to have to go to YouTube or Facebook. So let's show you what the law is. It's not something I'm making up, and that's the law. Until it becomes repealed, that's the law. This is I'm going to make it as big as I possibly can. And I would ask you guys to help me. Let me know if you're able to see that. Visibility window. I'm looking for. Let's see all my stuff. Okay, hold on. That's not what I'm looking for. Let me confirm. Questions. Okay, here we go. All right. If you are on Facebook and YouTube, okay, y'all need to go over there. Y'all just share another screen. Because you guys confirm, somebody confirm if you're able to see my screen. Can someone on YouTube, Facebook confirm that you're able to see my screen? And I'll read it for those on TikTok and Instagram, but I will try to just send an email. Lydia helps me with lives. Okay. And so she usually would get back. All right. So this is what it says on the USCIS.gov website itself. What if, go back here. What if my abusive U.S. citizen or permanent resident spouse or parent filed a Form I-130 petition for alien relative on my behalf, which is still pending or was withdrawn? And this is USCIS.gov website. If you are the beneficiary of a Form I-130 petition for alien relative filed by the abusive spouse, parent, or child, you will be able to transfer the priority date of your Form I-130 to the Form I-360. This is extremely important for you if since it may result in an earlier priority date and a shorter waiting time for getting a green card. This is what it says on USCIS.gov, their website, questions and answer. Where did they get this? What is the basis of this information? And that's what I'm going to show you now. So that's that. Let me show you what the source of that information came from, the Immigration and Nationality Act itself. Okay, so this is let me read this for you. This is Immigration and Nationality Act, 8 CFR 204, section 204.2, subsection H, subsection D, subsection 2. And what it says here is, and I'm going to highlight, well, let me highlight it. If you've seen that right here. Okay, this is where I'm highlighting. I'm going to read that. This is the law itself. A self petitioner who has been the beneficiary of a visa petition filed by the abuser to accord the self petitioner immigrant classification as his or her spouse or child, however, will be allowed to transfer the visa petition's priority date to the self petition. The visa petition's priority dates may be assigned to the self petition without regard to the current validity of the visa petition. What that last sentence means is just that if it's denied, revoked, withdrawn, it doesn't matter. As long as you were the petitioner, the beneficiary of that I-130, then the law allows you to be able to transfer the priority date to your I-360. I hope that just puts that to rest. So I can't say, okay, Anthony said you can't do that. That's fine. This is what the law says. So there you have it. Okay. And if you need that link, Miss Endless, actually do me a favor. Send me a reminder. I'll put it up, or yeah. All right. So that takes care of that. Let me go to TikTok, Instagram, and get some questions. And it's already past. Okay, I think that's what we just talked about. Hello from Indiana. Hello. Birthday loading. Listen, y'all, I have no plans besides just not going to work. That's it. That's it. Combined birthday wishes. Thank you. Um, some people are just bold. Hey, listen, you're going to tell me not to speak Yoruba language. I'm like, go. 10 minutes later, yeah, Miss Savannah Grace. Let's see. Okay. See a spot and will say, oh, that's true. You know what, Bill? Y'all, can you tell y'all I don't play. See a spot was close to my house. I can imagine. I'll just be there every night. For those who got their 10 years green card through val, when can they apply for citizenship? If your abuser was a citizen, then 3 years, whether or not you're still married to the person. If the abuser is a green card holder and still remains a green card holder, then it's going to be 5 years. Buhari Law School was behind your secondary school. Oh, really? You know, Abuja people, who remembers Yahuza Suya behind GT Bank in Wuse too? I probably do. But then again, it's been a long it's been a long time I left Abuja, like, geez, 21 years. Yeah? What's it? Oh shit, there. Oh shit, there. Let's see. How long does it take for a VAR appeal? Y'all, we won another appeal today. Lord Jesus, listen. Whenever, either way, because appeals are hard to win. That's just the truth. So whenever it comes to whether it's been dismissed or sustained, I'll go back to read my brief and the meat of my argument. And so I just okay, why did they reason this way? What can I do better? Or why did they reason the way? Why did they agree with me? What was it? And when I was reading, I was like, okay, no, I'm not who I believable. No, I think it is, and like, but the best part is just being able to call your client and say, we've got another shot at this. Just knowing that, what the doctor see, of our office, like, y'all need to reconsider this nonsense you did, because this ain't making sense to us at the appeal office. So they've got a good point. You got to reconsider. Nothing like it. But how long does it take? It can go. It varies. I've had some come back in as little as 4 or 5 months, and I have some pending over a year. And then it depends on, so the way appeal works, when you file an I-290B appeal for a VAR case, the procedure is you send it to Vermont Service Center, but before it gets to the Administrative Appeals Office, they initially send it back to the officer who made the decision of denying your case to read through what you've sent, and for them to decide whether or not they're going to reconsider and change their decision. So basically, your appeal is initially treated as a motion to reconsider. If the adjudicating officer decides, no, there's still nothing you sent that's going to make me change my mind, then they transfer it to the Administrative Appeals Office. Then the appeal itself kicks in for a brand new de novo review. So that's how the appeal process goes. And it can go as fast as 4 or 5 months, and it may linger a year, 18 months. Yeah, disclaimer. General information only, nothing specific to your case. Anything specific to cases or discussed in the paid consultation. Hello, Miss Lady Adipa. How are you? What if USCI sends you a letter for not believing your case and tell you to reply them for more evidence about your abuse case, and after you send them, how long they're going to reply you? It just depends. There's no set time for them to respond. Red font, even the blind will see. And when USCI has traumatized you, you've got to devise ways to not go crazy. Mr. in the Sanctuary, yes, you've got to be intentional with USCIs. I'm telling you, you've got to be intentional with it. It's, yeah. Can I file for my in-law while I have my wife application filing ongoing? I think you asked that question last time, and I asked for clarification. Do you mean that you are the citizen? Well, you can't file for an in-law. I'm not really sure what you're asking, Shion. Are you asking if your wife is maybe your? Can you explain who is filing for in-law? Are you the one trying to file for your in-laws, or who is a citizen and who's wanting to file for the in-laws? I think that's where we can start. I remember when my parents turned 50, the whole family came from far and near, endless party for the weekend. I can imagine. I'm telling you, my estranged wife had me in an asylum application, which is still pending since 2016. We got separated 2 years ago, and I'm kind of confused as to what to do. What advice would you give? Sit down with a lawyer and discuss your case. Can you file an I-130 and I-45 form together if you are an immediate relative, meaning you're married to a citizen? Yes, you can. If you're married to a green card holder and you're valid non-immigrant status and your priority date is current, yes, you can. It's free information, but the entitlement just, I reserve my comment. After I-290B approval, what is next? Usually it's sent back to the originating office, and that's usually where you have to be on their tail. Like, yo, they've already told you guys to change your decision. Yeah, and let's get this ball rolling. And so that's basically what's next. And it shouldn't, if it's a motion to reopen, for the most part, that's usually the fastest I see. They reopen, you just get a notification that they've reopened that. Depends on what your I-290B was for. I-290B is the same to use for a valid appeal as well. It just depends on what you filed it for. Okay. My I-45, I-130 is pending, and my wife is threatening to divorce and pull our petition. Can I go ahead and file I-360? What you need to go ahead to do, first of all, is sit down with a lawyer and discuss your case, have your case evaluated, and see whether or not you've got basis to file for a valid case. Can I request USCI to act on pending I-45 if I've got approved for I-130 2 months ago? Yes, absolutely, you can. I actually did that on 2 cases. They responded to one yesterday, responded to the other one today, saying, "Hey, lady, your cases are still within our presence time." Like, well, I've never had that happen to me until just recently, because I usually have both approved at the same time. So it's like, well, it's new to me. So y'all just have to slow your roll, because there's no reason why it's still pending if we just had an interview together. But you can. May God continue to strengthen you, Sister Laura. Thank you, Mr. Rotimi. I appreciate that very, very much. Okay. We can't see it. Yeah, you can't see it. I can't share the screen. Well, I don't know how to share the screen on Instagram. So, but it would be on Facebook and or YouTube. You got to work permit with an advance parole. Then after you get your green card, USCIS terminates the advance parole. Is that okay? I don't know what you mean to terminate. They may close it. But terminate, I'm not understanding what you mean. But if you have a green card, don't worry about anything unless, yeah, well. Thank you, Miss Endless Sanctuary. Yeah. I sent an email to you. Okay. Okay, I think I know who that is. Okay, let's see. Is it 3 years after the green card has been received or 3 years of marriage? I'm assuming your question relates to citizenship. The 3 years or 5 years has to do with how long you have been a green card holder, not how long you've been married. After a prima facie notice has been received, how long more for an approval? Generally, that can take anywhere from 33 months to 36 months, so about 3 years for it to be approved. Okay. Can I use I-796C, notice of action, to renew my driver's license? Depends on the state you live in. Can I expedite EAD if I have a job offer? You can expedite anything. It just depends on what evidence and if your reason for expediting falls within the acceptable basis to expedite. Okay, real quick on Facebook. Hello, Mr. Taryn, how are you? I was in immigration court before PD was decided on. I filed for VA. I have been approved to work EAD, travel, parole. Would it affect me when I return back? I'm trying to understand what you're asking. If you're asking, I would not advise to change any name right now. Just leave things as they are. But if you're asking if having your immigration court proceedings terminated, they've been terminated, but even though they've been terminated and now you have advanced parole, would that be a problem with you coming back? I don't know anything about your case. I can't speak to your specific situation, but generally, as long as the proceedings have been terminated, you shouldn't have any problem. Generally. My I-131 got it denied 2 weeks ago. If I want to reapply for that, do I need to pay the fees even if I have a pending I-485 or it's free? If you pay the fees, the $1,225 for your I-485, you don't have to pay filing fees for the I-131 even if you have to reapply. Looking forward to the promotion I-751. No, I didn't say. See, this is the problem. Sweet, no. That's not what I said. I said I will consider doing a promotion. I didn't even say about I-751. I said consultation is what I said, not 751. This is the problem. I'm not even. That's what I. So let me say it again. I said for birthday week, I may consider doing a promotion for consultation. That's what I said. And you can play this video back again so you can hear that loud and clear. Hello, Ibidayo. Oh my God, that is my. We've been friends for what? Jeez, Ibidayo, how long have you been? Let's age ourselves a little bit. Since 1989, right? What are you still doing? Oh, what time is it in Nigeria? Until you Sunni. Can I call you when you're done? If you want to discuss your case, you have to call my office and they'll give you the information to set up a paid consultation. Thank you, Miss Creasy. So, best Miss Creasy has gone through that. Listen to that. Do not do not change any name. Just let sleeping dogs lie, y'all. Just leave it alone. Don't change any names. Just get your card. Deal with name change later on. If my I-751 is pending after my fingerprint and I'm facing a big problem with my spouse, can I leave the marriage? Maybe consult with a lawyer. That would help you to decide what you need to do, how best to move forward in your case. Okay, that's all the questions I can take. Tomorrow is still a work day. Gotta, like, yo, things are changing here because the kid is in college, so TJ, I'm back to being TJ's full-time driver. So it means I have to change my sleeping habits and go to bed early and work according to his school schedule. Yeah, but I count it all joy, like, because it's been quite a ride. Like, when I think back, it's been 21 years. Yeah, that I've been in this country. And when I think back at when it looked so impossible, I'm looking forward, and I just thank God for His grace. That for chapter 45 is right around the corner, and I have many, many reasons to be grateful and to thank God. And I think one of my greatest blessings is being able to, even being able to do this work that I do. It's hard to teach. It's hard to explain something that is just part of who you are, and you cannot teach passion. It's just something you have or you don't. And one of my greatest blessings, just looking ahead in this new chapter, is just being grateful that God has found me worthy to be able to use me as an instrument in helping others who are going through the same journey that I have been through. And that's one of the greatest gifts I could ever ask for a birthday. So just knowing that it's being a part of someone's story that changes their lives, even if it's not something the outcome we expected. The prayer is that we always have what we ask for. But it's also a reminder for me to know that as long as God remains God and there's still breath within us, we got to keep going. We can't stop. We got to keep going, because I'm a firm believer that we didn't come this far for Him to not feel us. No. And that's one thing that kept me going all those years. I don't know if my mom is here, but when you talk of frustration and anxiety and almost depression, not anything diagnosed, but just thinking back at everything that I had to go through. And, I transferred. I was driving home today and I was thinking that everyone in my family, my siblings and my parents, God rest my dad, so they got their green cards, family routes. I'm the only one who actually got my green card through employment because I was a derivative beneficiary from my ex-husband's case. So that whole process took us through all kinds of visas. Like, when you talk of being, joined with somebody with immigration status, not just family and everything, because everything he was on, I had to. But at a point, I was independently on an H-1B visa. But I'm grateful that I look back and I can say thank God. I can say thank God for the journey, because it makes me appreciate it now. And it makes me understand where everyone else who is still trying to get to that final destination is going through. And that's where the compassion comes into play. I'm very assertive. I'm very, very matter of fact. But the compassion I have is, a huge part of that is because I know what it feels like. Nobody can tell me that you can't imagine it. I can, some things you tell people, I can only imagine what you feel like. In this, I can tell you, I know what it feels like. And I pray that even as we continue to do this journey together, that you would agree with me in faith. Because I always say, if you're defeated, if your mindset is defeated, then what's the point of trying? But if you're agree in faith and you're already winning here, and you're speaking it before you see it, and knowing that it's going to happen for you just the way God has intended it to happen, There's nothing anyone can do to change that. There's no immigration officer who's going to sit in any field office that's going to change anything. If I haven't seen it, I've seen all kinds of stuff. But when I think I've seen God do things that I'm like, wow, that is mind blowing, then he does something like, okay, you know what? You know what? Like, my client, I called her earlier today and I said, you're not going to believe this. Your appeal was granted. And she was like, Sister Lawyer, that's all you're like, I got to stop you right there. Without mincing words, I got to stop you right there. It wasn't me. This is all God's glory. He uses people because there's nobody who's got knowledge, wisdom, understanding that is not from God. All those combined individually, they're all gifts. We didn't create them ourselves. We were given. So I already said the day I begin to think it's on anything that I have done is the day I begin to fail. But because I'm very, very convinced, I have seen it happen in my life, and I know beyond anything, fully convinced that all this is because of God. And because he decides that he's going to show us favor at different times, it doesn't mean he's forgotten about your case. It just means that it wasn't your time, and he just decided somebody's season is right now. But we've all got our season. So I pray that we just hold on and just be patient. Africans, we ain't patient at all. I'm the one of the least impatient human beings you ever meet. But I also tell myself that I know that patience has been a big part of why God has brought me this far, to go through the journey that I had to go through so that I can see it, and I appreciate it, and then turn around and be able to empathize with others because I know what it feels like. So just hold on. Let's just keep holding on, knowing that there is no record of failure with God. It shall